They're the people you thought you knew and the people you want to know more about. The all-new Biography Channel. Step out of your life and into the lives of movie stars and moguls. From their most dramatic on-screen performances to the untold drama of their lives.
Every night, you could live another life.
Movies, biographies, and documentaries, 24 hours a day. The Biography Channel. Call your cable operator or satellite provider.
Since the 9/11 attacks, hundreds of suspected terrorists have been captured, and the government is trying to figure out just how to deal with them.
To an extent, we're making it up as we go along.
The manner in which we conduct trials will speak volumes about our character as a nation.
But the administration's approach to wartime justice is creating a growing storm of controversy.
I consider myself one of the lucky Middle Easterners after September 11th, until I got arrested.
On my orders, the United States military has begun strikes against al-Qaeda terrorist training camps.
October 7th, 2001. Less than a month after the 9/11 terrorist attacks, the U.S. invaded Afghanistan. Thousands of members of al-Qaeda and the Taliban were captured. More than 600 were taken into custody.
They were rounded up actually for several reasons, one of which was to get them out of Dodge, basically, because they were extremely dangerous in Afghanistan.
Eugene Fidel is president of the National Institute of Military Justice, which has been monitoring the government's prosecution of the alleged terrorists.
The second objective was to find out what they might know by way of valuable intelligence. And a third objective was possibly, to the extent any of them may have committed war crimes that are punishable, they would at least be available for prosecution.
But how should the U.S. prosecute this new kind of enemy? Will they be tried by military commissions or eventually released, like prisoners of war? In a post-9/11 world, what is wartime justice? The first place to go for an answer is 1,700 miles south of the ruins of the World Trade Center. Camp Delta, Guantanamo Bay Naval Base, Cuba. As U.S. soldiers stand guard, more than 600 voices rise in prayer during the last of 5 Muslim services for the day. The government says the men behind these walls, most captured in the attack on Afghanistan, are the foot soldiers of terrorism. They have been brought to this secluded base, commonly known as Gitmo. This 45-square-mile tract of land and water has been leased by Cuba to the U.S. since 1903 for use as a military base. It was hastily overhauled to conform to a new mission.
Garrigan! Oh, Cochran! Here's Hermiston! Here's
Gitmo now holds 2,600 troops, 1,900 of whom make up the Joint Task Force, comprised of men and women from all branches of the military. Brigadier General Rick Backus commanded Joint Task Force 160 from March to October 2002. His unit was responsible for the security and care of the captives, who come from 40 different nations.
We treat them as extremely dangerous individuals, and certainly we have to maintain that respect for them.
Although the influx of detainees has slowed, they're still coming in from overseas, joining those who have been detained since day one. Colonel John Perrone managed the detention process for JTF Gitmo from May to December 2002. The unit now in charge of all detainee operations.
They arrive via air bridge operations and are brought here. They're provided medical screening.
After a ferry trip across the bay,
they're processed and administratively in terms of getting their next of kin identified. They're allowed to send a letter home saying that they're in our custody, and they get a identification band, they do fingerprints, DNA.
They are brought to Camp Delta, and their imprisonment begins. Due to military restrictions, the Point was not allowed to film the detainees.
Their days are really rather mundane. They generally wake up early in the morning around 04:30. We respect their religious customs and allow them to read the Quran and participate in religious activities. They're also given recreation time. Generally, lights are out about 10 o'clock.
But this isn't simply a prison. These wooden huts off to the side at Camp X-Ray hint at the other mission going on at Gitmo. That's where Joint Task Force 170 conducted interrogations of the detainees before the move to Camp Delta. Now interrogations are conducted inside the Delta compound.
No one has been sentenced, if you will. The purpose of coming down to Guantanamo Bay is to be interrogated. It's an interrogation operation.
Colonel Dennis Fink was the spokesman for JTF 170 from April to September 2002, the unit that previously conducted the interrogations.
It's a very deliberate and slow process. The more experience the criminal, the more experience his resistance in an interview. We understand the process, and we're getting through it, and we're going to continue as long as it takes.
He can't say much more about what's going on behind these walls.
We really can't get into the interrogation process. We don't want any future guests, if you will, to be tipped off in any way as to what to expect when they get down here.
The interrogation mission of Gitmo highlights the first and perhaps most important wartime justice decision the Bush administration has made since 9/11. The government designated the men held here as unlawful enemy combatants, not prisoners of war, which allows more extensive interrogations to take place.
We wanted to avoid the implications of applying a label, prisoner of war, and all the protections that come with that.
William Haynes is general counsel for the Department of Defense. When captured Al-Qaeda and Taliban began pouring into Gitmo, he was one of the people who had to figure out how to classify the captured men.
Our adversaries in this conflict were not following those same rules that would normally apply in a conflict. There is a benefit to being treated as a prisoner of war that must be earned by a fighting force.
If the incoming suspected Al-Qaeda and Taliban were labeled prisoners of war, they would have been entitled to full protection under the Geneva Convention of 1949.
The Geneva Convention is a post-World War II treaty with many signatories. It's administered by the International Committee of the Red Cross, based in Switzerland.
The agreement provides for the humane treatment of prisoners of war, including medical attention, religious freedom, and living conditions similar to those of their captors. The Geneva Convention also stated that prisoners of war could not be questioned. All they were required to give their captors was the proverbial name, rank, and serial number. However,
the Al-Qaeda did not sign the Geneva Conventions. They're not even a state. They weren't entitled to the protections that flow from the rules.
The Taliban posed a more difficult issue because they, in effect, governed Afghanistan, a signatory to the Geneva Conventions. But the administration argued that the Taliban were not entitled to POW status.
These are the people who have joined an international conspiracy of terror to use unlawful means in order to target innocent civilians.
Viet Din is an assistant attorney general at the Justice Department. His office was charged with crafting the legal framework needed to prosecute the global war on terrorism. And he says these suspected terrorists are not legitimate soldiers.
Not only are they enemy combatants, they're also unlawful enemy combatants because they have violated the traditional rules of combat that define the conduct among nations.
This method of labeling detainees gives the administration a crucial advantage. By avoiding the prisoner of war designation, it has been able to conduct interrogations.
The principal objective is to find what information they have that can help us continue to protect the American people.
Vincent Canestraro is the former head of the counterterrorism unit of the CIA.
I think most of the information that is acquired from, say, detainees in Guantanamo is rather low level. But they do have knowledge of the camps. They have knowledge of techniques. Some of them may have knowledge of particular operations that were discussed.
Controversy over the U.S. treatment of the prisoners began shortly after they arrived at Gitmo in January 2002. Early in the detention process, the detainees were kept in Camp X-Ray because Camp Delta had not been finished. In January 2002, the Pentagon released these photos of the detainees in a holding area with their hands bound and wearing blindfolds. The pictures provoked outrage from some human rights groups, such as Amnesty International. Secretary of Defense Donald Rumsfeld denied that the prisoners were being mistreated in any way.
Let there be no doubt the treatment of the detainees in Guantanamo Bay is proper, it's humane, it's appropriate, and it is fully consistent with international conventions.
Both the Taliban and the Al-Qaeda are considered detainees and are treated the same humane manner in accordance with some of the conventions of the Geneva Convention.
That controversy died down when the prisoners moved from Camp X-Ray to the better equipped Camp Delta. But there were other questions. Some believe that the reason the government wanted the prisoners at Gitmo was to avoid the jurisdiction of any U.S. court. Gary Solis is a retired Marine Corps judge advocate.
There are very few places in the world where these people could be held and be free of the jurisdiction of a U.S. federal court, certainly nowhere in the continental United States.
And why is it that U.S. courts have no jurisdiction at Gitmo? The reason may seem like a strange one, but it's true. The land underneath the military base is still owned by Cuba, and therefore beyond the reach of a federal judge. Because the base is not on U.S. soil, the detainees' fate will be determined by the White House and the Pentagon, not by the courts. They have yet to be charged with specific crimes. They have no access to lawyers, and they will stay put until the government decides to either release them or bring them before a military commission, a trial far different than the one found in standard criminal courts.
The manner in which we conduct trial will speak volumes about our character as a nation.
More than 600 alleged members of Al-Qaeda and the Taliban have been detained here at Guantanamo Bay, Cuba, since January 2002. The men are being held as so-called unlawful enemy combatants, so the rules that govern prisoners of war do not apply. Eventually, some of these men may be tried for crimes against the United States. The White House has decided that that justice may be dispensed by a military commission. In November 2001, President Bush instructed the Secretary of Defense to establish guidelines for military commissions, also known as tribunals.
The President decided to establish military commissions because he wanted the option of a process that is different from those processes which we already have.
The question, of course, is just how different it might be. William Haynes is General Counsel for the Defense Department.
What we first did was we looked at the Constitution. We looked at the President's order. We sought help from the legal community. We spoke with our colleagues across the river in the Congress on an informal basis and began drafting the rules.
Yale law professor Ruth Wedgwood consulted with the Bush administration on the issue of commissions.
After a long 4-month process of drafting rules with advice from a lot of graybeards around Washington, including some old Democratic graybeards, we now have what I think are a quite fair set of guidelines for how to conduct even a trial.
According to guidelines released in March 2002, any prisoner at Camp Delta may be subject to a military commission. His journey would be in some ways similar to, in other ways strikingly different, from the American criminal justice system. The prisoner would be taken from his cell in Guantanamo Bay and led to a makeshift courtroom. No regal courthouses of criminal trials, no high judge's chair. This is a sparer justice. This is wartime justice. There would be no cameras in the courtroom, but reporters would be present, except at times where the military decides that security requires tighter control.
The only occasion for closing a proceeding in a military commission is the moment when sensitive or classified information is going to be presented, and that's to keep Al-Qaeda from hearing it.
Instead of a jury of 12 peers, the accused would come before a panel of 3, 5, or 7 military officers.
It will be very similar to what we're all used to in the American justice system. There will be a prosecutor and a defense counsel who will be provided free of charge to anybody who is subject to a commission. There will be rules of evidence. There will be procedures that will be accorded to the accused, such as a presumption of innocence.
A defendant who is found guilty in a standard criminal trial has another chance. His case can be appealed to a higher court. Under the tribunal system, the defendant will also have another chance, but his review board would be made up of only 3 people appointed by the Secretary of Defense.
There is an appellate process to a panel which has the right to reverse and remand. It has independent authority to reverse a conviction and send it back for retrial or for dismissal. There can't be any use of the death penalty without a unanimous verdict of a 7-member trial chamber.
The last court of appeal in an American criminal case is the Supreme Court. 9 justices who have the final word on legal issues in the United States. With the military commission, however, the Secretary of Defense or the President of the United States has the power of final review. The defendant's fate will rest in their hands. Retired Marine Corps Judge Advocate Gary Solis says these guidelines are similar to past U.S. military commissions.
Military commissions have been the vehicle that have prosecuted non-U.S. citizens for violations of the law of war. They are the ideal vehicle for the trying of the Al-Qaeda and Taliban. They are traditional, they have history, they've been okayed by the Supreme Court.
Military commissions have been a part of the broad canvas of American law, let's say since the Mexican War in the 1840s. They were used in World War II and in the aftermath of World War II.
Perhaps the best-known example is the case of 8 Nazi saboteurs caught on U.S. soil in 1942. They were tried and found guilty by a military commission. The Supreme Court upheld the proceedings, ruling that unlawful combatants are subject to trial and punishment by military tribunal for acts which render their belligerency unlawful.
The court very clearly recognized the authority of the executive to conduct a military trial for Nazi saboteurs who were caught in this country on our soil. Military commissions are an exercise of restraint in order to bring justice even to those who would seek to exploit the rules of war against us.
But critics are concerned that the courts are being cut out of the process. Harvard Law School professor Lawrence Tribe argues that without independent review, this kind of wartime justice isn't really justice at all.
If we are told by the executive branch, we have followed all these fancy and wonderful procedures, now we're going to go ahead and execute someone, who's to know whether, in fact, they did? It's only an independent check by a court that is not answerable to the president that can give us assurance that the procedures are worth the paper they're written on.
But the administration maintains that in the war against terrorism, the U.S. needs a tougher mechanism to prosecute unlawful enemy combatants.
The fact that it is not identical to the civil justice system is not surprising. This tool, the military commission process, is a tool available to the president as the commander-in-chief of the armed forces.
Our Constitution is not a suicide pact. Of course the nation must be secure. But part of our security rests in our belief that it is not a unilateral system in which it's entirely up to George W. Bush as president to decide exactly who is a threat to our security.
Another critic is Joe Unnick, who served as deputy White House counsel under President Carter and in the Justice Department under President Clinton. He says the U.S. has to set an example of fairness to the Arab world, especially for the next generation.
To some extent, we are fighting for the allegiance and the loyalty to get young men who may now be 13, 14, 15-year-olds to see that we are not the great Satan. Make it clear to other countries that military tribunals are only to be used in very, very narrow circumstances, and that generally you use civilian courts.
So far, not a single detainee at Guantanamo Bay has come before a military commission, and a handful have been returned to their native countries.
The people we have in Guantanamo are clearly enemy combatants that posed and continue to pose a threat to the United States. And while the conflict continues, we're entitled to hold them.
But there's another front in the world of wartime justice. And the question is how to deal with alleged terrorists who are U.S. citizens.
Who is to say that the president will not determine who else is an enemy combatant?
The foreign detainees being held at Guantanamo Bay are only part of the wartime justice picture. In July 2002, John Walker Lind, the so-called American Taliban, was tried in federal court. He pleaded guilty to charges of serving the Taliban and carrying explosives, and was sentenced to a 20-year jail term. Zacharias Moussaoui, the alleged 20th hijacker and a French national who entered the country on a temporary visa, will also be tried in federal court. Although the government has not explained its reasons for prosecuting these two men through standard criminal channels, both Lind and Moussaoui have been accorded their rights under U.S. law. But two other alleged enemy combatants and U.S. citizens are not getting the same treatment. The Bush administration is controlling their fate, and controversy has been brewing.
They're simply being detained in what you might call was a kind of private or one-man Guantanamo Bay situation.
Yasser, Y-A-S-S-E-R, Esam, E-S-A-M, Hamdi, H-A-M-D-I.
In November 2001, Northern Alliance forces in Afghanistan captured this man, Yasser Hamdi, who was allegedly fighting on the side of the Taliban. He was transported to Guantanamo Bay for detention and interrogation. U.S. authorities determined that he was an American citizen, born in Baton Rouge, Louisiana. Therefore, he could not be held in Guantanamo Bay. He was shipped to Norfolk, Virginia, and has been held at a Navy brig since April 2002. Because the government labeled him an unlawful enemy combatant, 22-year-old Hamdi can be held indefinitely without being charged. Frank Dunham, a federal public defender, would be working as Hamdi's attorney. He was appointed by the courts, but he has been blocked by the government from meeting or speaking with him.
I believe he should have the full measure of constitutional rights that we would give any citizen, including, most fundamentally, the right to talk to a lawyer about his present situation.
Viet Din of the Justice Department says Hamdi has been lawfully detained in the war against terrorism. More importantly, keeping Hamdi under tight wraps has been necessary and in the country's best interests.
These individuals have chosen to take up arms against the United States or to join this international conspiracy of terror in order to exploit the traditional distinctions we make in times of war between enemy combatants and innocent civilians.
A federal judge ruled in August 2002 that Hamdi should at least have a right to legal representation, but the Fourth U.S. Circuit Court of Appeals overturned that decision. The court cited the government's authority to capture those who take up arms against America.
We now believe the government just intends to hold him indefinitely.
The other American being held in a Navy brig in Charleston, South Carolina, is so-called dirty bomber 32-year-old Jose Padilla.
This guy Padilla is a bad guy, and he is where he needs to be, detained.
New York Attorney Donna Newman was appointed to represent the alleged terrorist.
The public has to be concerned that Mr. Padilla's constitutional rights are being violated because it could be them next. Who is to say that the president will not determine who else is an enemy combatant?
Born in Brooklyn and raised in Chicago, Jose Padilla was a Latino gang member who served 3 years in an Illinois juvenile center. After another stint in a Florida jail for assault with a handgun, he converted to Islam and eventually adopted the name Abdullah al-Muhajir. According to intelligence officials, in 1998 he moved to Egypt and then traveled to Afghanistan and Pakistan, where he allegedly met with a lieutenant of Osama bin Laden. Investigators believe that in Pakistan, Padilla learned about explosives and researched techniques for making dirty bombs, low-payload nuclear devices that would be detonated in U.S. cities. On May 8, 2002, federal agents were waiting for the suspected al-Qaeda convert when he flew from Zurich, Switzerland, and landed at Chicago's O'Hare Airport.
They gave him a chance to testify before the grand jury. He didn't want to cooperate.
On June 10th, Attorney General John Ashcroft announced Padilla's designation as an enemy combatant and his transfer to a naval military jail in Charleston, South Carolina. His lawyer has been unable to contact him since the move.
He's still not charged. We have all these allegations, so if there is so much evidence, charge him, like they did with Mr. Lynn, like they did with Mr. Moussaoui.
If he's serious about his project, which he seems to have been, then let him wander around is not a very good option. In ordinary crime, you just take your chances. With Padilla, it's a very different scale of possible damage.
The government has yet to publicly present its evidence against Padilla, and constitutional law expert Lawrence Tribe is concerned that the Bush administration and the military are cutting the courts out of the process.
If the courts are allowed, as I believe they must be under our constitutional tradition, to review the basis on which the administration is labeling someone, like Jose Padilla, an unlawful enemy combatant, then most of my concern goes away.
Retired Marine Corps Judge Advocate Gary Solis also believes the government should explain its rationale.
I have no sympathy for Padilla as an individual, but the fact is he's a United States citizen. Now, we have been told by the Attorney General, by the FBI, that he's an enemy combatant. Well, this is a status that should be confirmed by a court. Let's see some evidence.
The Supreme Court does have the power to order the administration to present evidence against suspects like Padilla. For now, these decisions are being made in the lower courts, and these men can be held for as long as the White House deems them a threat. Viet Dinh remains confident that the judicial system will give the administration the latitude it needs to designate a suspected terrorist as an unlawful enemy combatant without answering to a judge and jury.
The courts will recognize that the executive has considerable discretion as commander-in-chief in order to prosecute this war against terror. Wars are waged not by lawyers and judges, but rather by men and women in fatigues who risk their lives, their sweat and blood every single day on the battlefield.
The government and its agencies, however, are not infallible. After 9/11, some innocent U.S. citizens and legal aliens were rounded up and were held under a veil of secrecy.
I consider myself one of the lucky people, or lucky Middle Easterners, after September 11th. That is, of course, until I got arrested.
The attacks of September 11th sparked one of the largest criminal investigations in U.S. history. Hundreds of people across America were detained. An undisclosed number of them have been held as material witnesses.
The Department of Justice has taken in a number of individuals that we have deemed to be, quote-unquote, of interest to the investigation into September 11th.
Some of those detained after 9/11 have been released. Many have been deported on immigration violations, but only Zacarias Moussaoui has thus far been charged with a direct connection to the terrorist attack.
They started at around 1,000, and they fluctuate to now, whereby it is less than 100 persons that we currently hold for immigration violations, less than 100 persons we currently hold for criminal charges, and a handful of persons that we hold pursuant to judicially issued material witness warrants.
A material witness warrant allows the government to hold someone in order to, quote, prevent a failure of justice. But critics say the government is using the warrants too broadly.
The purpose of the material witness statute is to preserve testimony from a witness who you think might not be available for a later trial or a hearing. That isn't what they've done. They've used the material witness warrant as a way to get people off the street, as a way to detain people without ever charging them with a crime.
The danger is the government hasn't always picked up the right man, as was the case with 31-year-old graduate student Abdallah Higazi. Higazi, an Egyptian citizen, spent much of his childhood living in the United States. After serving in the Egyptian Air Force, working in ground-to-air communications, he received a scholarship to study computer engineering in the U.S., and he began studying for a master's degree at Brooklyn's Polytechnic University in September 2001. The school arranged for temporary housing at the Millennium Hilton Hotel right across from the World Trade Center. The morning of September 11th, Higazi was asleep in his room on the 51st floor.
All of a sudden, I heard a sonic boom, and the hotel was shaking. And I was like, oh my God, what happened? I saw a lot of people running, and I saw paper flying. I saw this huge hole with a lot of smoke, black smoke.
15 minutes later, the second plane hit the South Tower. Word came over the hotel public address system, urging everyone to evacuate the building.
I ran out. I saw a lot of people running, scared, crying. As soon as I got out, I realized that I didn't have my passport. I forgot it inside.
Higazi stayed with friends and soon found an apartment on Staten Island, New York. Over the next 2 months, he continued with his studies and applied for a passport at the Egyptian consulate.
They issued me a temporary passport as a means of identification. But it wasn't exactly good because there was nothing to prove that I entered the United States legally. And since I am Middle Eastern, it did give me quite a scare.
On December 17th, Abdallah's fears proved justified when he went back to the Millennium Hotel to retrieve his passport and other belongings. 3 FBI agents were waiting for him in the hotel lobby. They said they found a radio used for ground-to-air communications in the safe in his room. Higazi denied any knowledge of such a device.
Since it said on my resume that I was in the Egyptian Air Corps and did ground-to-air communications, they believed that I had to know what it was. But the fact is, the type of devices I worked on would pretty much fill a room. I never saw anything like that device before.
Higazi was arrested as a material witness and for the next month held in solitary confinement at the Metropolitan Correctional Center. Because of this designation, no information about his case was released to the media. Robert Dunn was appointed his attorney.
It was more difficult accessing him because he was a material witness. It was more difficult getting information on him.
The FBI kept insisting the radio was his. All along, Higazi maintained his innocence.
I was willing to take serum. I was willing to accept being hypnotized. Anything to prove that, indeed, I was telling the truth. They gave me or were supposed to give me a lie detector test that eventually turned into an interrogation.
During the long, grueling interrogation, Higazi says he finally gave in to the pressure. He changed his story and told the investigators that it was his radio. He was immediately charged with lying to federal agents.
After I was officially accused by the FBI, my attorney, Robert, he said, "Congratulations, you've been officially charged. Now we know what your rights are."
In January 2002, shortly after Higazi was charged, an American pilot who had been staying on the floor below him returned to collect his belongings, including his ground-to-air radio. Investigators now realized their mistake. Higazi had been telling the truth all along.
I'm eventually taken to this office where I meet the U.S. Marshal. And he goes, "What's your name?" I said, "Abdallah Higazi." He said, "Where do you live?" I said, 360 Barlow. He said, "You could leave." I said, "Sir, I don't understand." He said, "You're free to go."
With little explanation, Abdallah Higazi was released. The next month, February 2002, he found out why. Hotel security guard Ronald Ferry had lied about finding the radio in Higazi's room. He would eventually be found guilty of lying to the FBI and sentenced to weekends in jail for 6 months. Had Higazi not been taken as a material witness, information about the radio might have been announced in the media, and the true owner may have come forward much earlier.
Due to the grace of God, the pilot who actually owned the radio came forward and claimed it. Had he not come forward, Mr. Higazi would have been in great difficulty.
This experience changed a lot in me. I've become a lot easier to be angered. If somebody would just indicate, even as a joke, that I'm not telling the truth, it makes me boil. I wasn't like this.
There may be more like him still in jail. The Bush administration argues that such detentions are necessary for security. But critics of the wartime justice policies say that all of the secrecy is creating a credibility problem.
It is completely question-begging to say that because we are pursuing security, and security must be preserved above all, no one dare question the measures that we are taking. That, it seems to me, represents an accommodation of our normal protections of privacy and liberty with the needs of national security. But accommodation is one thing, abdication is another.
Now the administration is looking to expand its powers to prevent further attacks. The government is again struggling to find a balance between protecting the populace and upholding the Constitution. September 13th, 2002. In Lackawanna, New York, 6 men, all alleged members of a terrorist sleeper cell, were apprehended by the FBI. One of the men has already pleaded guilty to attending an Al-Qaeda training camp. The arrests have been hailed as an important victory for law enforcement, but they could not have been accomplished if not for new powers acquired by the FBI. Today, American law enforcement personnel can monitor the public in ways they could not before the attacks on 9/11. Public libraries, places of worship, and websites are all fair game. Access that has come from legislation signed into law in October 2001, called the USA Patriot Act.
The purpose was just to be plain and simple and unmistakable. To say to Al-Qaeda, we're going to get you.
When we looked at the laws in the book after September 11, I was amazed to find in certain areas we had harsher penalties and more investigative tools to investigate healthcare fraud, for example, than terrorism.
The new law updated search and seizure rules for the information age, increased coordination between the FBI and CIA, and prioritized investigations and prosecutions of terrorism.
The most important part of the Patriot Act is the provision that lets the FBI and the intelligence agencies share and pool their information freely. Second important thing in the Patriot Act, I think, was to be a little bit more permissive in when you can have a foreign intelligence wiretap.
The 300-page law allows FBI agents to conduct, without a warrant, general searches of websites and internet chat rooms for clues related to terrorist activities. Former CIA counterterrorism expert Vince Canestraro believes it has made the job of those who track terrorists easier.
The Patriot Act has basically helped the anti-terrorism effort because it has opened up the product of criminal investigations to CIA analysts. It's also lowered the standards by which the FBI can conduct investigations.
Terrorism does not fit neatly into organizational boxes, and we need all hands on deck.
But critics like former Clinton Justice Department official Joe Onick fear the expansion of surveillance powers authorized by the Patriot Act goes too far.
I think we have to be smart and not overreact in ways that aren't going to help us. For the first time, you can subpoena all the records of a library or university to see what books have been read. Furthermore, the FBI could go now to any mosque or to any Muslim student association whenever it wishes to. Now, is that really going to get us much useful information, or is it going to, in some degree, alienate organizations and citizens whose support we need?
The Patriot Act also allows the government to detain any foreigner whom the U.S. Attorney General certifies as endangering national security and hold him for 7 days without charging him. Critics are worried that in this time of great concern over the threat of terrorists in the U.S., innocent Arab Americans are likely to be targeted by the Patriot Act.
None of us are suggesting that we don't protect ourselves, but I think we do have to understand that to win the war on terrorism really means to convince people around the world that the values that we stand for, democracy, tolerance, the rule of law, are the right values, and that we in the United States subscribe to those values even under the threat of terrorism.
The Bush administration responded quickly and forcefully to the new threat. And now, as the conflict wears on, their response is being measured both by our allies and by the American public.
Over a long period of time, the support for the increased abridgment of civil liberties is going to weaken. And I think there will be more and more complaints, particularly about people being detained as witnesses, people being detained without recourse to a defense counsel.
In wars past, the nation has returned to the norm soon after the conflict ended. But now the U.S. is engaged in a struggle with no end in sight, much like the Cold War, which lasted more than 40 years. Unlike that war, however, this time the enemy has no clear address and has shown the ability to attack us from within. Under these conditions, the debate will rage on over the right balance between liberty and national security.
What government does, law enforcement does, what our national defense men and women do, is to protect liberty by providing security, especially at a time when our security is being threatened and the safety of the American people is being jeopardized.
We shouldn't give up what are some of the great strengths of our democracy, including, I think, an independent civilian judiciary and adherence to the rule of law. I think those are the things that have helped make us the most powerful nation in the world, and we shouldn't forget those now.